authorise.
Yes, Mr. Williams.
My Lord, my lunchtime researches added nothing to my earlier researches on
That's helpful. Thank you for doing that.
May I turn to the permit?
Yes, of course, yes.
And that's in the core bundle at 155.
Right.
And for your note, I give the references in my skeleton of 19 to 30.
Thank you.
As to overarching submissions, my Lord, the permit has the effect, in my submission, that there shall be no heavy metal contamination of the environment through surface water or through fugitive emissions. And I separate those out deliberately because that's the way the permit operates.
Either through surface water
Or fugitive
or
emissions.
fugitive emissions, yes.
And my second overarching submission is that there are references to heavy metal fractions being soluble in the permit,
Yeah.
which in my submission is inconsistent with the proposition that the EA made the same mistake as is set out at 245 of the supporting information.
Right. Well, I won't ask you about the second because you can develop these two.
Yes. So at 152 of the core bundle, my Lord, you looked at this with Mr. Stedman Jones, the introductory note.
Yeah.
The point I would highlight at the bottom of page 152, twofold. Again, the clear separation between the process water system and the surface water system. And there are, at the bottom of the page, no discharges to sewer. So any pollution within the process water is either addressed on-site or taken off-site. So it says only uncontaminated surface water will be discharged. And my Lord, you'll have seen from the plan, from the site plan, that the system for transferring the IBA from the incinerator part to the IBA part is intended to be by covered conveyor, and the system intended to take the IBAA, that's the aggregate, secondary aggregate, off-site is to be by covered truck.
What is aggregate?
Aggregate. Once the incinerated bottom ash has been treated, it forms an aggregate that can be used for road making, similar sort of products such as that.
I see.
Right.
And that's its principal use.
What was the reference you had just now? You gave us a reference.
I was looking at CB 152.
Yeah, but then there was something else.
The reference to the plan, the site plan, which showed the incinerator area and the IBA area, which was at SB 315.
Yeah. But do you want us to look at that? Or
Lord, no, I just wanted to indicate why the separation of process and surface water is so important in the scheme of the facility.
Right, I'm not sure we're fully understanding this at the moment.
I think
just let me ask the question and then perhaps you can help us. Maybe the wrong question. Are you submitting to us that I'll perhaps use inappropriate descriptions, but the integrity of the process water system as such is sufficient of itself to deal with potential contamination of the surface water system by dissolved heavy metals, or is that completely false?
Lord, that's not flawed. The yes is the answer to that, subject to one caveat.
Right, I want to sorry if I'm being ponderous.
No.
I do want to get this down in the way that you want to submit it to us, but this may be an important submission in your argument. I suspect it is. In which case because we haven't, I think, all three of us yet quite, at least I haven't, I know, grasped this point that you're making, I want to get it very clear in my notebook.
The easiest way to do that, I suspect, my lord, is to look at supplementary bundle page 22.
Right.
Which the court looked at.
Yeah.
But if I may just look at down the left-hand side of the two systems,
Yeah.
there's ERF surface water runoff is the top left box, if I may call it that.
Yeah.
Now that is dealing, as it says at 231,
So ERF surface water runoff.
that's dealing, the second paragraph under 231 is dealing with all other surface water from the ERF, so roadways and areas of hard standing,
Yeah.
broadly the internal estate roads. Box 2, rainwater from building, is treated slightly differently because that obviously is fresh rainwater falling from the sky and it goes into the rainwater harvesting tank.
So just a second. Rainwater from building. Yeah. Say that again.
That goes into the rainwater harvesting tank.
Yeah.
Which is the grey box. The majority of that then goes into the dirty water tank as part of the process system,
I see. That's that line there.
where it's used for a number of uses within the sealed drainage system, including quenching contamination.
Right. So if we put I'm going to put an arrow that runs towards the dirty water tank.
I said the majority, my lord, because there is the potential, you can
Yeah.
just see in very small letters above the box,
It's the overflow.
for some overflow to go into the surface water system.
As a rule of thumb, red is inside and blue is outside.
In terms of where the water is arising from, my lord, yes.
Yeah.
And under 231, the first subparagraph, deals with that surface water from the roofs and buildings.
Yeah.
My lord, the third box, the blue box on the left, but now entering into the red,
We're now inside the process.
yes, but it's
I'm gonna
also
sorry.
called.
Call
sorry.
that. Forgive me interrupting. I'm going to call that 3, box 3.
Thank you. Box 3, entitled IBA Surface Water Runoff,
Yeah.
is dealt with at paragraph 2.3.2.5.
2.3.3.5.
2.3.2.
Sorry, I beg your pardon. Yeah.
And so that surface water stays within the sealed system at all times.
Could you just repeat which of the boxes does 231 link to, as you put it?
The first paragraph under 231 will be box 2 using Lord Justice Lindblom's numbering.
And the second paragraph?
The second paragraph is dealing with box 1.
Yeah. Right.
That's right. It helps then. If we write in our margin under against 231 against the first subparagraph box 2, yes,
Yes,
and against the second subparagraph box 1, yes,
my lord, yes.
and then know this is a bit sort of rough and ready, but if we go to 2325, we need to write in the margin box 3, is that right?
Well, yes. And just to help, it's not the clearest numbering system, but paragraph 2.3.1 is headed surface water.
Yeah.
2.3.2 is process water.
Yes.
And then all of those sub-paragraphs
Yes.
beginning 232
Yeah.
are dealing with the process water
Yeah.
system. There's then a change at 233 to site drainage.
Yeah. Understood.
So my lord, the point I was emphasising is that surface water might ordinarily be thought of as being any water falling on the surface of the facility.
Yeah.
Here there's a clear distinction to that which arises within the IBA, which is directly and only within the sealed system, from the roofs, which is primarily in the sealed system, and it's only the estate road that is not within the sealed system.
Yeah, that's box 1, is it?
Yes.
Yes, it's broadly estate roads, you said, yes. All right, well now, have you finished that phase?
Yes.
Well then I just want to capture your submission, which I was attempting to do before you started to explain this to us. And the gist of it was that the process water system will the integrity of that system under the permit will be effective to overcome any risk of the escape of heavy metal solution, dissolved heavy metals rather, in surface water.
Subject to one caveat, which is the fugitive emissions point.
All right.
So that there's
can you, I'm sorry to be
no, it's brilliant.
rather demanding, but could you formulate the submission as you would wish to make it to us, please?
My lord, yes. That the requirements for the system to be designed and operated.
Sorry, take this at dictation speed. The requirements for the system
To be designed and operated in such a way as to prevent the unauthorised and accidental release.
Sorry, in such a way as to
Prevent the unauthorised and accidental release of any polluting substances,
sorry,
which is the wording of 46.5.
prevent the unauthorised and accidental release
Of any polluting substances into water is secured primarily by reference to the separation of the water systems. So
When you say by reference to, do you mean by?
yes,
By the what? The separation?
of the process and surface water systems.
Yeah.
With fugitive emissions
Yeah.
being addressed through a range of operational controls.
Right. Is that it? Because I'm going to read it back to make sure I've got it right. That's it, is it? I'm going to read it back to you now to check I've got it right. The requirements for the system to be designed and operated in such a way as to prevent the unauthorised and accidental release of any polluting substances into water is secured primarily by the separation of the process and surface water systems, with fugitive emissions being addressed through a range of operational controls.
And if I may then,
And what I'm, sorry, I appreciate that I may be taking you slightly away from your own course, but you're going to need to tie that, aren't you, to the provisions of the permit? Is that what you're proposing
Well,
to do
yes.
next?
yes.
Right.
If I may do that, Your Lordship.
Are we going away from the flow diagram?
Yes,
plan?
my lord.
Yeah.
And I think you're also going to need to satisfy us, aren't you, that the operational controls intended to deal with fugitive emissions will themselves leave no possibility of any heavy metal solutions getting through the system.
My lord, in my submission, I'll need to satisfy you that the agency reached a judgment as to whether that test was met as a result of the operational controls. And the best reference I can give for that is within the decision document.
Right. Do you want to take this in the sequence of going through the permit first and then going to the decision document to address my Lord's point at that stage?
My preference would be to look at the permit first, but I'm happy to go to the decision document or just give the reference.
Yep. Thank you.
Sorry, I hadn't fully understood the SB 22 plan. That the challenge here really runs along the top line of the plan, does it not?
Yes.
That's the focus of the case that you're having to meet, together with a little bit of overflow water coming in from the second line.
Well, that's the focus of the challenge.
That's the focus of the challenge. Does anybody know what the area is that is covered by box 1 and what the volume of waters that were anticipated would be within that?
Lord, as far as I don't know that I don't think that information is within the
Well,
court plan.
it's a very big site,
It is a big site.
according to the other material that we've had. You've been referring to roads, have you, on the site as being a particular?
Yes, based upon what's said at SB 22, the other surface water being roadways and areas of hard standing. My Lord, all of the hard standing within the IBA process and storage facility is enclosed by building.
Yes, but we're talking here about the bits that aren't
Yes,
for
the
fugitive
residue. Yes.
emissions. Right, so there isn't any data as to
No.
how much road we're talking about and how much water we're expecting is going to be flowing onto that road and then into whatever the box 1 process
My Lord, no.
provides.
No.
Thank you.
Yes, right.
My Lord, may I then go to condition 2.1 of the permit at CB 156?
Right. I'm going to keep the diagram open actually as you do this, in case we need it. Yeah. So condition.
2.1.1, my Lord.
Yeah.
The significance of this condition is that it specifies what activities are authorised by the permit. And those are identified in table 2.1. Sorry, 1.1.
Sorry, 1.1.
At CB 164.
Yeah.
The principal activity is the incineration. On the right hand side, in terms of limits of specified activity, it includes storage and processing of incinerated bottom ash. It then says that storage and processing of incinerated bottom ash and storage of incinerated bottom ash aggregate to be in fully enclosed buildings. Fully enclosed buildings is defined on 183, my lord. towards the bottom of the
Yeah.
page, and it's four walls and a roof, which is fully enclosed, subject to ventilation. So that's part of the approved activity. The other part of the approved activity I would draw attention to is at CB 164 again. Directly associated activities include surface water management, and the description of the specified activity is management of uncontaminated surface water. So that's what's approved of this facility.
Yeah.
My Lord, going back to condition 2.3, which is the operating techniques, the effect of condition 231 is that if you operate the site other than in accordance with the identified operating techniques, you're in breach of the permit. And my Lord, I make that point because in my submission that's relevant to whether or not the permit incorporates only practical operating techniques, which is my submission, or whether it would embrace a statement as to the solubility of water, as is found in paragraph 245, solubility of heavy metals in water, as is found in 245 of the supporting information. In my submission, to give sufficient certainty to the permit for this to bear the basis of prosecution or enforcement, it can only relate to the practical techniques and not, for example, is heavy metal, or to what extent is heavy metal soluble in water. That couldn't found the basis of a sensible prosecution in my submission.
Right. Is it going to be necessary, do you think, for you to take us back to 245 and isolate what you characterise as the technique or techniques?
My Lord, yes.
Can we go there now?
My Lord, yes, it's SB 27. And there is a degree of overlap between some of these paragraphs. For example, interceptors you will have seen referred to in more than one of the paragraphs supporting information. But my Lord, under 245, the first sub-paragraph describes operating techniques by reference to good housekeeping practices, spill kits.
So all of the first sub-paragraph is operating techniques.
Yes, my Lord.
Yeah.
The second sub-paragraph in my submission would also be operating techniques.
All of it.
My Lord,
It's
yes.
only a short one here.
Yep.
Right.
In the third paragraph,
Yes.
the first two sentences and third sentence are clearly not operating techniques.
So the first three sentences are not operating techniques.
In my submission, the fourth sentence would not be a operating technique.
Yeah.
The fifth sentence, in referring to the design of interceptors, would be.
Sorry,
Would be.
Would be. So it's in the third sub-paragraph, only the fifth sentence.
My Lord, yes. As I say, there's overlap there in that water interceptors are referred to at 2.4.4 as well. my submission for the purpose of this case is that the mistake is not an operating technique and is not incorporated in the permit as a result.
But is it not meant to explain what the operating technique is and what it's there for?
My lord, it may be. It seems it is a very confused.
I agree it's a confused
statement.
sentence, but one has to assume it was there for a purpose.
It,
And if doing the best one can to make sense of the whole of that third paragraph, it looks as though what the writer is saying is we are going to have an interceptor system preventing the discharge of, well, looking at the last sentence, suspended solids. And to understand what is meant by that, you look back at the rather garbled sentences before that, which seem to suggest that suspended solids will include any salts resulting from heavy metals.
but my lord, in a sense, that's my point. That sort of justification for a technique isn't the operating technique. The technique is enforceable whether it's justified by right or wrong science.
Well, I'm finding this sophisticated, to use that in its proper sense,
Which is
not a compliment.
not a compliment.
Because, I mean, the purpose of this paragraph, which is then carried forward in whatever measure into the permit, is that there's a proper system for preventing fugitive emissions from getting into the wider system. And so, you know, whether one sentence or another refers to an operating technique or not seems to me to be highly irrelevant. As presently advised, the question is whether what's being described here is an effective system. You can't leave out part of a system and then say, well, the rest is partly an operating technique and partly just an inaccurate description.
My lord, the point
I put that to you as a point to me.
My lord, in my submission, the interpretation of the permit does not incorporate the dissolution or otherwise of heavy metals as an operating technique. And the reason,
presumably your client gave a permit in order to make sure that the heavy metal didn't get into the outside world.
my lord, that is addressed through the separation of functions, the surface water versus process water, and the control of fugitive emissions. And my lord, the reason I deal with this point is because the appellant's case is that this was a mistake of fact made by the Environment Agency.
Well, I have the same difficulty with the way in which the case is put against you, because it seems to me to be going around the houses.
But my lord, that's why I deal with the incorporation point in
Look,
those.
let's get straight to it, as I see it. The last sentence of 245, third paragraph. The interceptors are designed to prevent the discharge of suspended solids and oils and grease. One might say, fine, but what about dissolved heavy metals? What's going to deal with that is the question, which assuredly that sentence does not answer, because it's dealing with something else. Where do we find the answer to the question asked by a local resident, for example? How are you going to deal with, i.e. prevent, the discharge of dissolved heavy metals?
My lord, the answer to that, referring back to the decision document,
Right.
if I may, is on SB 144 at 6.5.3. Because, if I may just remind my lords of the context, 651 on the previous page is dealing specifically with emissions to water, and that, as we'll see in the permit, is condition 3.1. And the way in which the surface water is addressed, I won't read out those paragraphs, but it deals with both the surface water as they described and the contaminated water, which is the processed water.
Yes, but here we have the difficulty that these paragraphs use phrases like based upon the information in the application, which, again, if the information is faulty, then so is this reliance on them going to be faulty.
Well, my
I think this leaves the glaring gap. It may be the separation of the closed system from the surface water system is absolutely fine as far as it goes, and probably deals with, for all I know, 95% of the problem, maybe more. But the problem is the remaining gap, which still has to be filled, based upon the possibility of fugitive emissions arising accidentally and being carried away by rainwater, with a partial or total dissolution of the heavy metals involved, and therefore not being caught by the filter and passing straight into the pond.
My submission in response to the use of words such as based upon the information in the application is similar to my submission in relation to what constitutes the operating techniques.
Right. Well, look, I'm sorry if I'm cutting across, my lord. I apologise to him. But on his theme, if I may, if we're going to have reliance on the information in the application, you must show us where the application answers the question I posed. How are you going to deal with dissolved heavy metals? Where is the answer to that in the application?
My lord, there isn't a sentence that I can take,
Right.
my lord.
Well, let's be absolutely blunt about this. Does the application or not deal with the question, how are you going to deal with dissolved heavy metals?
My lord, not explicitly.
Right, so the application, I at least get this, does not explicitly deal with the question, how are you going to deal with dissolved heavy metals? Right, but you said explicitly, so implicitly?
Implicitly, my lord, going back to SB 22, Supplementary Bundle 22,
Yeah.
in relation to surface water, the final paragraph under 231 explains that the discharge from the interceptors will be tested periodically to verify that it's not contaminated.
Well, that's after the event. That's not preventative, that's checking.
My lord, the checking is obviously after the discharge,
Yeah,
but in
where's
terms
the
of
I'm sorry to cut across. Where is the prevention?
232 is dealing with the process water, section 232.
Right.
So the prevention is, in the process water terms, contained within the system. So there's no emission. So any heavy metals dissolved in the
Sorry,
process.
where are we looking exactly?
Sorry, 232,
Yeah.
the entirety of section 232.
Well, can you isolate the passage that deals with preventing the escape of dissolved heavy metals?
My lord, not separating out dissolved heavy metal
Well, that's what the case is about.
from other contamination.
But that's what the case is about.
But my lord, a sealed system
Is it not what the case is about?
is much.
Right. Well, let's focus on what the case is about. Where is what the case is about dealt with in the application document?
Lord, I can't take you to a reference to heavy metal dissolution. I can, however, my lord, draw to your attention that the effect of the process water system being sealed is to prevent any contamination from that source, which includes heavy metals.
But again, that's not what the case is about. I mean, everyone accepts that the the closed system is, as I say, fine as far as it goes, and probably deals with a very large part of the problem. But the difficulty is is precisely the surface water system and the possibility of it becoming contaminated as a result of fugitive emissions.
My Lord, in response to that, if your Lordship goes on to SB 26,
Yeah.
dealing with emissions to water, 2.4.3, and then that's dealing with the uncontaminated surface water. 2.4.4 is dealing with contaminated water. So the system operates by preventing the release of fugitive materials. So the IBA areas are enclosed in fully enclosed buildings. The conveyors are enclosed. The trucks are enclosed. The objective of all of those is to stop fugitive IBA from getting outside of the...
The last sentence on 26 is the nearest we get so far.
My Lord, that is dealing with the ordinary water system, if you like. It's not...
It's dealing
I
with,
couldn't
what,
say
it's dealing with, as I understand it, what we're dealing with now.
But my Lord, I don't advance that as dealing with heavy metals, that final sentence.
Well, it doesn't, because it may deal with suspended heavy metals, but it doesn't deal with dissolved
No.
heavy metals.
But my Lord, those...
And so we're trying to look for something that does deal with the fact you can't simply say that inside you've got contaminated waters and outside the waters are ipso facto not contaminated. I mean, they're in a different category, but there is a risk of contamination that jumps out from all of these documents.
My Lord, what the agency can do is put in place measures to prevent the fugitive emissions occurring. And in 2.4.4, over the page, this is the supporting information. You'll recall my submission is that this isn't an agency document. This is the applicant's.
Yes, but we started on this because the permit, which is what we're really focusing on ultimately, cross-refers to and incorporates 245 and other passages. On one analysis at least, the only place, or at least the salient place in the supporting information dealing with what happens to heavy metals is 245. 245 we know, because we've read it very carefully, does not deal with the discharge of dissolved heavy metals. It just doesn't. We look at all sorts of other references which are not, as it were, directly focused on that question. We're still left then with the concern that this is not squarely addressed in the supporting information. And if it's not squarely addressed in the supporting information, how is it then dealt with in the permit, is the question.
My Lord, may I just finish on 2.4.4?
Of course, yes, I'm sorry.
The second paragraph is dealing with where there may be a spillage, for example. Adequate quantities of spillage absorbent materials will be available on site.
Yeah.
And at the end of that subparagraph, water interceptors will have penstock valves to prevent the discharge of contaminated surface water in case of an incident on site. So if there were some spillage. The next two paragraphs down also refers to spillage and accident log. So if there is an unexpected release by way of a spillage from a truck, for example, leaving the facility, there are specific measures for dealing with that. I recognise it's not specifically referring to heavy metals, but it is dealing with how a route, a pathway, as your Lordship said earlier, between the IBA and the wider environment. And I, of course, recognise, as I did at the outset of my submissions, that 245 contains an error. But I return to the submission that unless it's shown that that error was made by the agency, then that does not make good an error of law.
Well, you've still got to show us how the environmental permit deals with dissolved heavy metals.
Lord, may I go back to the permit?
Please.
And we looked at condition 2.3, which took us on to that discussion.
Yep.
Emissions, condition 3. My lord, the 3.1 deals with point sources, and your lordship looked at S3.1, and there is no identified emission from a point source for water. So the permit does not authorise any contamination or pollution from the attenuation pond.
Yeah, well, that's one thing. But we're not talking about authorising pollution, we're talking about preventing it.
My lord, that's a measure of control in my submission, because it means there is an obligation on an operator to operate a site in compliance with the permit. There may be accidents.
Well, do you rely then on 311 as preventing pollution by dissolved heavy metals?
Lord, yes. It would be a breach of the requirement of the permit that any discharge is uncontaminated.
Right, let me just get this then. It would be a breach of condition of 311 and thus the permit.
My lord, yes, and also I would refer back to 211.
Well, wait a minute. If any, did you say this? If any water polluted with dissolved heavy metals escaped from the site. Yes?
Lord, it would have, yes, it would have to be measurable.
Well, yes, but that's it's assumed, I think, in all this that there must be an objectively measurable quantity.
Yes,
Is that right?
yes.
And the other condition you rely on is
3.2, which is emissions of substances not controlled by emission limit.
yeah.
My lord, that phrase is defined in Schedule 6. On page 183.
Yeah, sorry.
I'm so sorry, which is the phrase we're looking at the definition of?
Emissions of substances not controlled by emission
Oh,
limits.
thank you. Yeah.
Emissions of substances to air, water, or land activities. So that you say that's broad enough to catch dissolved heavy metals.
My lord, yes. To breach the condition, of course, it has to cause pollution.
Well, I'm going to remind myself of what 46.5 says. Designed and operated in such a way to prevent the unauthorised and accidental release of any polluting substances into ... surface water and groundwater. So you say 321 then,
I do, my lord.
311 and 321 in combination and individually achieve what Article 45(6) requires.
My lord, yes. And may I also draw attention within the permit to pre-operational condition 10, which is on page 167, CB 167.
CB 167.
At PO 10, which requires, if the appellant is to undertake on-site processing of IBA, the operator shall submit an updated dust management plan after detailed design stage to the Environment Agency. It then says the plan shall also include details of the IBAA storage building to demonstrate that storage will be in a fully enclosed building.
And what was the condition you referred to before that?
It's pre-operational condition 10, the PO stands.
Yes, but what's the key into that from the condition, from the
Well,
permit?
that is introduced by reference to the operating techniques, because the dust management plan is referred to on CB 164.
Oh, wait a minute, sorry, coming back to 2.3, operating techniques. I just want the connection into table 1.4. Where do we find that?
My lord, in table S 1.2,
Yeah,
the dust management plan, it says on the right hand side, and as updated in response to pre-operational condition PO 10.
oh there it is, right, so that's the route.
Because what happened during the course of the application was the agency stipulated that the building should be fully enclosed.
Right, so the route is condition 231 to table S12, yes,
Well, yes.
to table S14, PO10. Is that correct?
And forgive me, Mr. Harwood kindly points out condition 2.5.1 on CB 158 requires those pre-operational conditions to be discharged.
Sorry, which one?
2.5.1 CB 158.
Yeah. Thank you.
And my lord, the final reference in the document I'd like to provide is in 3.5.1, condition 3.5.1, which requires monitoring specified in the following tables in Schedule 3. Little c is the residue quality in table S3.4, and S3.4 on page 176 the third box down requires, before the use of a new disposal or recycling route, monitoring of bottom ash, the total soluble fraction and the metals soluble fraction. It's on page 176.
Right, so bottom ash,
And soluble, if you read across, they're all bottom ash for the first three.
Yeah.
It's the third one down.
yeah.
And that would have to be complied with before the IBA on-site processing was brought into use. Again, I make that point in the context of my submission that the EA was not labouring under the error of thinking that metals didn't dissolve.
Are those metals the ones with which we're concerned, the ones which are listed there?
They include heavy metals.
Those. Would you accept this proposition that what matters is not, it's for the agency are not concerned with whether their permit says that pollution will be prevented or not, but with whether the system which their permit authorises would prevent pollution or not. Because we're not concerned merely with what's on paper, but with what the paper authorises. Isn't that the process that we're involved in here?
Lord, I accept that, subject to the caveat that obviously an important purpose of the conditions is to provide an enforcement function for the agency to ensure that the operator does operate the facility in such a way as to comply with the
But
conditions.
if the makeup of the facility is such that there is inevitably going to be an ever-present risk of pollution, then any permit that ignores that is not really dealing with the issue of it.
Well, in the specific context of Article 46.5, the answer to that must be that in order to grant the permit, the agency should be satisfied that 46.5 is complied with, subject to the conditions that are imposed.
So we're not really concerned with whether the agency understood the science or not, because it understandably presents the suggestion that it didn't, but with whether the system which it went on to authorise actually has the effect that the agency is there to guard against.
Well, look, that's the case that I'm facing now. It's not the basis upon which the claim was made, which is there was an error of fact made by the agency.
Well, in a sense it is, because whichever way you like to frame the claim in its main substance, ultimately the question arises in a claim for judicial review, what if any relief should issue? So the question is, and I'll put it in paraphrase, does it matter? And it matters if, potentially it matters if the permit itself doesn't do what it should be doing. So ultimately, in a claim of this kind, however formulated the grounds may be, we need to look at the question of whether the permit is actually effective to discharge the legislative requirements. That's why our focus has been on the question, well, what does it do to prevent the escape of dissolved heavy metals?
I recognise that, my lord. I make the point because the judgment below obviously was very much focused on E and the factors, and of course my skeleton addresses that case, as it were.
It does.
Because there are a number of points that I have to make about whether or not the agency was under that.
Oh,
that error.
yes, but I mean the agency, I'm sure, would accept as a regulator that it must do its statutory job effectively. I'm sure it recognises that.
Of course.
And the question here is whether it has done. Ultimately, that's the question.
My lord, you have my submissions on the permit.
Right.
I am conscious of the
Yeah, well,
time.
I mean, let's see where we are then with your argument. What more do you want to say about the permit? Nothing, I suspect, from what you just said.
Nothing other than points I've
So
made.
you've drawn attention to all the provisions of the permit that you say are germane to the question.
Lord, there's one submission I do need to make, which is in relation to the operating techniques on CB 164. There's a reference in that to paragraph 2.3. Which is a reference to This is a reference to all of the section 2.3. 2.3 is simply an introduction paragraph that then introduces the water system that we looked at in some detail. So the water use section is in my submission incorporated.
So you say that to understand that sensibly, do you?
Yes,
It has to
you read-
include all of the paragraphs within 2.3.
Well, yeah.
All right.
And well, that has some significance because that suite of paragraphs includes the reference to the periodic testing of the material discharging from the attenuation.
Yes, but I'm sorry if I've asked you this already, forgive me, but do you accept that periodic testing cannot be equated to prevention of itself?
By itself, it cannot, my lord, I accept that. However, in the context of the obligation to ensure design and operation so as to prevent the release of polluting substances, it has a very valid role in enforcing the measures put in place. As your lordship can understand, things can go wrong on sites, or things sometimes don't operate entirely as expected, and this is a means of verifying that the measures designed and operational put in place are working as intended. So, my lord, I have nothing to add on the permit. I would like to make one or two brief submissions on the decision document, if I may.
Yes, of course.
I appreciate I've been going for nearly my allotted time, but we have looked at the decision document a number of occasions. I'll take this as quickly as I can. My lord, my first point is SB 80, which Mr. Stedman James drew to your attention. And this is relevant because it's, SB 80 4.2.2. This is identifying, as the title suggests, potentially polluting substances and the prevention measures. And your lordship looked at that earlier, which includes the references to the sealed system. SB 93, please. There's a heading minimising the installation's environmental impact, and it recognises that there can be different types of risk, including fugitive emissions as well as point source emissions. It then goes on to identify relevant measures and gets to 120, SB 120. It deals first with a number of other emission sources that needn't concern us. And at the top of 5.6, under the heading Other Emissions, it addresses the risk from fugitive dust impacts. And the final paragraph agrees that the risk of dust emissions is low, and there are a number of measures to minimise dust emissions included in the dust management plan, and it then refers back to 6.5.3, or refers onward to 653. 6.5.1 we looked at a few minutes ago. The only point I want to refer to here is at the top of page 144, which is the reference to the interceptors being tested periodically, and that the drainage system interceptor and penstock valve being subject to planned maintenance. And my lord, 653 is significant because this is dealing with the fugitive emissions. And it begins this section with the agency reminding itself of its duties under 46.5. It then lists a series of bullet points which have progressed further from those that were listed at 4.2.2 as to what are the measures as part of the facility, operational and design, to prevent fugitive emissions. And it concludes at the top of the page, the top of the next page, your lordships can read that.
What do you want us to read exactly?
Sorry, just from based upon the information in the application down to the end after it's referred to the fully enclosed building. Now, I obviously have to accept, if my lord puts it to me again, that this does not explicitly refer to solubility of heavy metals. But in my submission, this is identifying the range of measures that are in place to prevent there being the accidental and unauthorised release of polluting substances. There's no error in this section that anyone can identify. There's no misunderstanding of metal solubility, for instance.
Where in 653 is it dealing with the box 1 category?
Forgive me, I've just forgotten temporarily. Box 1 was the...
Sorry, supplementary bundle 22, it's our flow chart.
That's rainwater from building.
No, it's rainwater. Sorry, surface water runoff.
Well, Lord, through the 7th bullet point,
Yes.
it's dealing with preventing dust emissions, which are a number of measures, for example, keeping it wet, keeping it inside,
But
that would prevent it entering the surface water system.
I understand that's the whole point. But I mean, no system is perfect, and there will, it appears to be accepted from the whole tenor of the documents, be a risk of fugitive emissions. So my question is, where is, in these provisions that you're drawing our attention to, where is it stated how those are to be dealt with?
My Lord, the only answer I can give to that is by reference to the control of dust,
Right, so the answer is really that they're not to get there.
not together.
Right, and that once they've got there, nothing is said about them.
Well, my Lord, 651 is dealing with the emission to water, because 651 is dealing with the point source emission.
Yes, well, if they get there, then they're to be tested after the event.
But my Lord, my submission, I'm sure you have it, is that the judgment was in all the circumstances that those measures in combination prevent, to the A satisfaction, a breach of 46.5. It addresses 46.5 in terms. and it draws attention in doing so to the dust management plan and the full enclosure of buildings. And there's no, in my submission, infection by error in these paragraphs, and these paragraphs represent, together with the permit, the reasoning of the agency. So, wearing another public law hat, this is a matter of judgment for the agency, and there's no evidence in its own decision document that it erred.
Yes.
And my lord, there are, as the learned friend indicated, a number of references in Mrs. Justice Lang's judgment to the Annex 4. In the circumstances of today, I particularly don't want to spend time going through Annex 4, but I would welcome your lordship rereading of the pulled out points. The one I should deal with explicitly is, of course, on page SB 238. And my lord, there's the top three boxes on that page are all relevant, and your lordship, I believe, looked at all of them earlier in my learned friend's submission. The point I make is that when one reads through the consultation responses that are given, it is clear that the agency is recognising that metals will leach. For example, box 3 on that page. So when someone raises a concern about metal leaching, the answer is the process system will be sealed. And that's because the majority of the IBA contact will obviously be in the process system. When it comes to, at the top of the page, the concern about, although the statement in the application is quoted, the concern expressed is that the reuse of recirculating water, so that's in the process system, will result in heavy metal emissions, and silt trap won't prevent the release of dissolved metal salts in ash water. The point that's made in response is, don't worry, the sealed water is not going to be discharged at all. It will be removed off-site. So it's recognising the potential for heavy metal dissolution, but it's saying the processed water just isn't discharged. And my lord will have seen in relation to the other consultation responses that there is considerable reliance on the preventative dust management plan. My lord, I can content myself with those references together with those in the judgment, if that's acceptable to the court.
Of course.
My lord, I don't believe I need to say anything more on the supporting information which we looked at.
No.
So, if I may just make my final submissions on the grounds, your lordship may feel you've heard these already as we've been discussing
Well, we don't want to prevent you
the point.
making distilled submissions at this stage on the grounds if you wish to do so.
My lord, if I may make a few short points.
Of course.
The incorporation of the error,
Yes.
sorry, the incorporation of the operating techniques.
Yeah.
My lord, you have my skeleton argument at paragraphs 52 to 59, which is in the core bundle, at CB 3612.
Do you want us to look at those passages?
I'm happy for your lordship to note that I rely on those as an accurate reflection of my case in relation to the incorporation point.
52 to 59, yes. Yes.
My lord, ground 2, the misdirection as to mistake of fact. I continue to rely on 60 to 67.
Yes.
In particular 64, 65 and 66. The fundamental submission remains that when the court reviews any material produced by the agency, there is no error. My lord, the point about the dust management plan, if I may on that point refer your lordship back to Mrs. Justice Lang's judgment in paragraphs 55 and 56. There's no basis for criticism of this part of the judgment in my submission. What this is doing is simply recognising that the dust management plan is part of the measures that can prevent emissions through fugitive emissions. There may well be disagreement between the claimant as it was, now the appellant, as to whether they're adequate. But as I've submitted in the context of Article 46.5, that's a judgment call for the agency. It's also wrong, in my submission, to isolate the dust management plan, because it's the totality of the measures that your lordships have seen in the decision document that led to their conclusion on 46.5. And where we are now in relation to the margin of appreciation, I have nothing to add on that point to my skeleton at 72 through to 80. The final point I raised, my lord, we've analysed. It's the question of discretion and whether the outcome would highly likely be the same. And my lord, I rely on my submissions through discussion with your lordships as to the effect of the permit, and that in any event protects.
Yeah. There's no evidence, is there, for example, as to the Environment Agency's practice in these permits? In particular, does it regularly or sometimes impose conditions specifically addressing dissolved heavy metals?
My lord, there's no evidence.
There's no evidence, so we can't speculate about that.
My lord, unless I can cover anything else, those are my submissions.
Maybe that we've lost our live link. That's checked. It's still on.
So,
Thank you very much, Mr. Williams.
Thanks, sir.
Very grateful to you. Yes, Mr. Harwood.
My lords, I want to deal with the issues in this way
Yes.
of looking broadly at first, and then we'll get a little more specific in terms of how this facility will operate.
Right.
Then looking at the alleged error, the para 245 error.
Yes.
Conscious that we've gone over that quite a bit
Yes.
today, and then looking at in all the circumstances, whether there is some other form of public law error in respect of the Environment Agency's decision.
Right.
Because of course that's ultimately what we're concerned with.
Yeah.
And my lords, in terms of where we're operating on here, set out a few basics, if I may. Maybe getting a few this old ground, but let's have it in context. Firstly, this is an incinerator for non-hazardous waste. It produces two solid forms of residue, in terms of non-gaseous forms of residue. One is incinerator bottom ash, is what we are mainly concerned with. And that again is non-hazardous waste. There is also what's sometimes referred to as fly ash or air pollution control residues, which comes from the scrubbing devices there to get the really unpleasant stuff out of the gaseous emissions. That is usually considered to be hazardous waste. That is tankered off site, and that is dealt with separately.
Yeah, but we're not
We're not
concerned
concerned
here.
with that one.
Yeah.
We are concerned with the non-hazardous waste which results. That is the incinerator bottom ash. And there are perhaps 2 points to have in mind on that. One is that, the point which Mr. Williams made, that it is used in the building industry. It's used as aggregate. So it's material which you need to deal with properly. But it's material which is safe in that context. And a reference to that in the supporting information is SB 45, paragraph 292. It's also not simply a pile of dust. Particles of a variety of sizes, up to 150 millimetres, so 6 inches in old language. And my lords will have a reference to that in the dust management plan, SB 303.
Right.
The way in which it is processed is designed to ensure that, with except for 2 circumstances, the incinerator bottom ash is kept within enclosed buildings. And my lords can see the context of that if the court turns up the dust management plan, which is in a supplementary bundle. You've seen it. You've seen it quite a bit, but if we go, my lords, to page SB 300.
Thank you.
That's explaining the process.
Yes.
So, 3.1 explaining that it's a combination of boiler ash and bottom ash, quantity produced. Then we see the ash extractor in figure 2. Then we're told the water battle within each stream accomplishes 3 objectives. Point 2, it dampens the IBA to prevent the formation of fugitive dust emission. So when the IBA is produced from the incinerator process, it's dumped in water. So it takes the temperature down, but it also does mean that what you're dealing with it's not dry dust at that point, but it's damp, moist material.
Yeah.
The intention then is that that will be taken to the IBA facility by an enclosed conveyor, and we see that illustrated in figures 3, 4 and 5. That's the primary intention. So the dampened material will go by an enclosed conveyor into another enclosed building, which is the IBA facility. With that being an enclosed facility, there will not be any escape of the IBA into the surface water. Detection simply doesn't get out of those enclosed facilities. Within the IBA facility, so that will be enclosed, as also picked from the dust management plan, it will be dampened down for two particular reasons. One is that part of the maturation process, chemical processes, will continue within that. Will take some time. That, but also is to keep it as a fairly damp material to minimise the risk of dust escape, and also then for the subsequent handling. There are two circumstances in which the IBA may be out of enclosed buildings on the site. One of those, the first, would be if the conveyor isn't working. In that situation, the IBA will be taken from the incinerator building to the IBA building by lorry, and the lorry will be sheeted with tarpaulin over the lorry.
So it's taken within the site
That's within the site, my lord.
to the IBA building. Yes? By lorry. By sheeted lorry.
By sheeted lorry, and my lord, that's a sheeted lorry
Yeah.
covering the damp material. The IBA has gone through the water bath.
Yes.
The other situation is when the IBA or the IBA aggregate is taken off the site. And I put it in that alternative fashion because the permit accommodates two situations. One is that we process the IBA into aggregate on site. The other is that we don't process it on site and it's taken off site.
Yeah.
In terms of what the permit is covering, at that point, it's the movement of the IBA, again in a sheeted lorry, from the IBA facility building to the edge of the site. Beyond that point, it's subject separately to sort of waste carrier control, also subject to the highways and road traffic legislation in terms of preventing spillages. But those are the two situations which IBA or IBA aggregate may be moving around the site outside buildings. And so those are the only two situations in which the issue of the surface water will come to be a potential consideration. And the first point, of course, on that, which I've made before, but I'll just repeat very briefly, is that the IBA will be damp material contained in sheeted lorries. The Environment Agency expressed the view that they were quite content with the material being kept in tarpaulin lorries. I think you've seen that already, but reference in the decision document is to SB 275, where the concerns explicitly raised that tarpaulins are not adequate to contain action that can leave in the site.
Yeah.
That should be in airtight seals. So the first point is that the regulator is happy with that movement around to the extent it occurs.
Yes.
Secondly, if there is a spill, there is an accident of some sort, then the mechanisms are put in place to clear that up. And we've seen the references to there being spill kits available, and to the immediate clear out of matters. That's maybe helpful just to take the court to two of the references in the supporting information, if I may. The first of those is the section on spillage management, which is at page SB 24. So, my lord, paragraph 2.3.3.1. So, excuse me, 2.3.3.1.
Yes.
And that deals with spillage management, in part after chemical and fuel storage, but also more generally. So, if my lords go to the continuation of that paragraph in SB 25, reference in the first paragraph on that page to the good housekeeping practices, then no material will be discharged from the internal road network which could potentially contaminate surface water runoff. And that will include necessarily IBA. And my lords, that's a reference which encompasses the potential consequences of a particular form of material being discharged or escaping, which would include the effects of any of that material being including dissolved heavy metals. It includes the solid material, it includes that in any part that's in a liquid form. So it emphasises the controls, and then in the final paragraph we have 2.3.3.1. In an emergency condition, such as a spillage or vehicle accident, the surface water discharge penstock valves will be closed. Any spillage or leak will be isolated, retained, and remediated locally, as on the road network. Penstock valve will retain all surface water runoff within the drainage system, prevent its release in the environment. Retained surface water will be tested and transferred off-site to an appropriate permitted waste management facility. If necessary, the drainage system will be emptied and cleaned prior to being reopened. And to take Lord Justice Henderson's question, a penstock valve, my lord imagined a sluice gate, that's the sort of facility it is.
Yes, I mean the basic point being it can just cut off
It
the
goes
water
off.
supply,
So
acting like a dam. Yes.
Absolutely, my lord. If there's a spill,
Yes.
then it'll get cleared up, cut off the drainage system. So if anything does get in there, then it won't go beyond the drainage system, and also be cleared out. It does involve pumping out the drainage system and tankering all that material off-site, so it can then be dealt with at an appropriate licensed facility. That's the way in which we stop dissolved heavy metals from getting into surface water, so into the LRS and then into Stewart Lake and beyond. That's the mechanism, because the risk factor solely arises on those vehicle movements. It shouldn't arise if things are operating properly, that material sheeted. If there's a spill, that's the risk. We need to be clear up and we make sure that none of that material, even in dissolved form, gets off the site.
There was some suggestion that there could be other ways of contamination getting into the system, for example, from the clothes of people who've been working with IBA and things like that. And you may say that's de minimis, already too trivial to sort of bother about.
It's not a point which Professor Ramsden or
No.
anybody else have raised.
Well, it has been thrown up. I mean, I've read
we
something
have
about it somewhere yesterday, and I think it was mentioned this morning as a possibility. But
and what you have is an enclosed building, buildings which are negative pressure. What we tend to, in fact, do with waste facilities for odour reasons, because if the pressure is negative, anything open, doors open, air will go in rather than go out. So in odour reasons, you usually do a waste facility in that fashion. If the agency thought that there was such a risk from material on clothing that some step could be made, then that could be dealt with very, very easily in terms of the clothing that's worn and how that's
Presumably the clothing by the workers there is worn on site and donned and left on site, presumably at the end of beginning and end of a shift. Is that right? I mean, if we get down to that level of detail, but that's how it works, is it?
or a bit prompt whether that's the case, but there's no reason why that mechanism can't be put in place, and one would perhaps imagine. I'm told that the staff wear protective clothing.
Yeah, which they put on when they start their shift and take off when they finish their shift.
Yeah, my models perhaps will appreciate that that's, in a sense, that's the sort of issue that relates to worker safety and worker health.
Of course.
In terms of do they need showers, do they need to change clothes, gear, national cold war type sort of situations. Perhaps more than it being a route to get into surface water. But if that point, what was a point that was raised about efficacy and those measures, it's very easy to deal with those issues.
Right, so that's how it works. How does the permit ensure that it works that way, I suppose, is the question.
What the permit does is to require, firstly, to prohibit pollution from escaping, and my order in particular has the references to condition 3 of 2 1, is at CD 158. Because any of these matters are not subject to emission limits. So the condition 3.2 bites.
Right, so if we just focus on 321, emissions of substances not controlled by emission limits, excluding odour, shall not cause pollution. We're not dealing with odour. We're not dealing with an emission limit
That's correct.
substance. We're dealing with a no emission limit substance, which is dissolved heavy metals in water. Shall not cause pollution. And that means what in practice? For heavy metals dissolved.
Shall not cause harm or potential harm.
Is pollution defined actually?
Let's see.
No.
It's defined. We're just checking the regulation. It's defined in the industrial emissions
Yeah.
directive.
Yes, and the directive, and this can be understood as adopting the directive definition, can it?
I'm told Mr. Williams is defining regulation 2 as well, which we have got in front of
Or
us.
is it regulation 2?
Which isn't unfortunately the bundle of the.
Right, so just give us the references then. The definition of
The
pollution.
definition in the directive, my lord, goes to Article 3(2). We have a definition of pollution. Directive of direct introduction, result of human activity of clear substances into air, water or land which may be harmful to human health or the quality of the environment. And then sort of various other aspects as well.
And that definition is
kept.
So sorry, that definition is carried into the regulations. In regulation 2, did you say?
I'm told I'm still in regulation 2. definition which was passed up to me is pollution in relation to water discharge activity or groundwater activity means the direct or indirect introduction as a result of human activity of substances or heat into the air, water or land which may A. be harmful to human health or the quality of aquatic ecosystems or terrestrial ecosystems directly dependent on aquatic ecosystems, B. result in damage to material property, or C. impair or interfere with amenities or other legitimate uses of the environment. So that's with respect to water discharge activity. In relation to pollution other than water discharge activity, any emission as a result of human activity which may A. be harmful to human health or the quality of the environment, B. cause offence to the human sense, C. result in damage to material property, or D. impair or interfere with amenities or other legitimate uses of the environment.
Right.
My lords, that's in regulation to one of the permitting regulations.
If we come back then to 321 for a moment. We've looked at the first sentence, but we ought to look at the second. The operator shall not be taken to have breached this condition if appropriate measures ... have been taken to prevent, and then this, or where that is not practicable to minimise those emissions. So does that, could it be submitted on the other side that that is to water down the requirement of Article 46(5) or not?
No, my lord, it's not, because the objective is, of course, the prevention of pollution. There's the explicit prohibition in the first sentence. There's the essentially it's defence. Of course, these will work as in the context of a prosecution for breach of condition, among seven matters, of reasonable, essentially the appropriate measures being taken. And then, of course, what 3.2 goes on to do, 322, is to require further steps to be taken by a further emissions management plan which is to be implemented.
Is it possible to prevent the escape of heavy metals in surface waters?
Yes, my lord, it is, because the circumstances which arise here are that the only possibility of an escape is in the limited circumstances in which...
I understand that. I mean, you've made a submission which says, well, there's not very much of it, or there's not going to be very much of it. I understood that. But where it says steps to prevent, or where that is not practical, to minimise, I was just asking you, what are there steps that your client could take to prevent, by dealing with the box 1 process in some different way? By processing the surface waters so that it would prevent heavy metals getting into the environment.
Not that we would see as being practical for two reasons. One is that the surface water that we're dealing with is essentially rainwater that falls on the open areas of the site.
And it goes into a tank in the
It goes into interceptors.
Yes.
It goes into a drainage system,
Yes,
which includes interceptors, as it would do for
yes.
a variety of
Some of it
reasons.
gets caught by the interceptors, some of it
Of course,
doesn't.
and ultimately, my lord, that surface water system has to go. That surface water has to go somewhere.
Yes.
And the two places which surface water can go. One is ultimately into a watercourse. The other is to put it into the sewage system, which is discouraged for a variety of very good reasons for doing that. So the normal way of dealing with surface water from industrial facilities is for that to be drained with the appropriate mechanisms, which will include interceptors and may include penetrating valves and the like if there's a risk of an incident, is then to drain that into a suitable watercourse on the basis that by the time it reaches there it's going to be clean.
Yes. Well, can I deflect from my question only to return to it, which is there any data about volumes here?
My Lord, not that we're...
Well, you must know the size of the attenuation tank, or at least somebody must know the size of that. But we don't have any information about how much rainwater flows off this site.
My Lord, there's nothing there. One of the reasons for that is that what the permit is doing is explaining what has to be achieved, how it has to be done in terms of
Yes.
what mechanisms.
Yes.
But it's not giving
That's
you
what I'm asking.
detail.
That's what I'm
it's not
asking
giving
about.
detailed proof.
So the question to go back to it is there any practicable means of preventing the escape of metals that are not stopped by the interceptors? We're talking about surface water.
My Lord, the practical means of stopping the escape is, first of all, stopping any of the material.
The lion has got out of the cage. I'm trying to ask about how it stopped from getting out of the zoo. Right.
Once on the basis that we have, my Lord's assumption that we have dissolved heavy metals in the surface water drainage system of the site.
Yes.
That's my Lord's assumption. The way in which we stop that is by closing off the drainage system, the penstock valves, and then.
That's if you know it's happened.
Because the situation in which that will happen is when we're dealing with some form of spillage.
What happens then? Once you've closed off the drainage system, you know you've got dissolved heavy metals in your on-site water system. What then do you do with that water?
What you then do is, and my Lord, we deal with it as SB 25,
Right.
paragraph 2, 3.3.1.
2331.
Yeah, spillage management. We've just looked at that.
Yeah. So that's the answer.
Let's take my Lord back to it, if I may. The final paragraph of that paragraph deals with the emergency situation.
Right.
So I'm relying on you for your knowledge of this area. So are you saying that there is no method by which the water can be treated before it is placed into the attenuation tank? No way in which the possibility of it being contaminated can be eliminated before it goes into the attenuation tank?
My Lord, what I can say, instructions, there's no way in which that is done as a matter of routine. As is explained at 2331, if you have contaminated water in the drainage system, you can pump that out, take it off site to a facility that can deal with it. What you wouldn't be doing is essentially picking up all the rainwater which falls on the open areas of the site, although the site is primarily, as you can see from the diagram in SB 315, the site is primarily actually heavy buildings. That to treat all that rainwater on the basis that it may be contaminated. Now, referenced by a learned friend to what Professor Ramsden was saying about precipitation techniques, which called from chemistry, is where you add another chemical to a solution. That causes a reaction which then brings out some particular material from that. Now, that's a technique which could be used in respect of the air pollution control liquids, and is discussed by the agency in that context. It's not one that's raised in the context of dealing with surface water, let alone dealing with surface water when there is no evidence that there is actual contamination of that. The reason for periodic testing is actually you may periodically test something where we don't believe that there's going to be any contamination issue. If you think there's a contamination issue, or you are producing something which does have emissions of some substance you want to check or stop or keep an eye on, then you'd actually go for continuous monitoring. But it is, we are dealing here with a situation where prospects of problems occurring are slim for the reasons which I identified, and the mechanisms for addressing that are the ones which are set out in the supporting information, and also quite a bit set out in the dust management plan which we dealt with. So it's dealing with that degree of a situation that it does relate to accidents, including a spillage rather than less overall dramatic. And mechanism, you have the clean-up kits, you get it cleaned up, you shut off the drainage system, and then you see where there's any contamination in the water supply there, and then you deal with it if that happens. And that becomes very much a matter for the Environment Agency to reach a judgment as to whether those measures are going to be sufficient in doing that.
Is it possible that natural rainfall could itself contain elements of heavy metals in solution? I mean, one hears about acid rain. I'm not enough of a scientist to know whether it's a possibility that even natural rainfall could contain some of these pollutants in very small doses.
Don't have instruction on that point, my Lord, but my Lord will certainly appreciate that there are plenty of materials, including heavy metals, which one find in soils and
Yes.
and the like. What of course you're seeking to do is to avoid doing anything which is either making that position very worse or particularly doing something where it would then be harmful.
Yes, and I wasn't suggesting that it should be part of your client's responsibility to monitor the natural rainfall, but it could.
But we are dealing with substances which do exist, but not exist in some form naturally. They need to be dealt with very properly, very carefully. And that's the reason why we have very substantial waste facilities and the substantial regulatory regime that goes with it, and that is of course very much a national concern. But we're not here dealing with hazardous waste. We're not dealing with radioactive material. We're dealing with material which ultimately is going to end up in aggregates, and we'll be driving our cars over it. That's the nature of the material which we are processing with IBA.
Well, now let's just see where we are, Mr. Harwood. Are there other provisions of the permit? I mean, Mr. Williams has taken through the provisions that he would seek to rely on. Are there other provisions you wish to draw to our attention?
Those provisions have been obviously, I agree with Mr. Williams on the scope of what's incorporated in the operating techniques. I will recall condition 231 and the schedule. That refers to various paragraphs within the supporting information, and the reference to paragraph 2.3 is one which encompasses all the sub-paragraphs that are in 2.3. That's our interpretation of that document as well, which of course will then will bind us in that process.
Just pausing for a second. 231.
Which is page CB 156.
Yeah. Just wanted to see if this works as a matter of construction.
My Lord, of course.
We need to look at. Sorry. It's
that
table.
takes us to schedule 1, which is
Table S1-2.
S1-2.
The draftsman's technique here is where he's dealing with a particular section in the supporting information document, but not seeking to incorporate everything within it. He goes to a three numeral reference.
Yes,
You submit, whereas when he or she is including everything in a particular subsection, there's no need to do more than say 2.3 or 2.8 or 2.9.
that's correct.
That's the approach.
Yes, my Lord. So that brings in those additional paragraphs.
Right, well, I think we understand that.
the final point I want to make on the permit, which takes
Yeah.
us on to the error, is that, as my lord points out, the permit identifies that there may be soluble metal fractions within the IBA. That's in Schedule 3 and Schedule 4. So the Environment Agency were aware that the IBA may include soluble metal elements within it. So when we come to think about paragraph 245 error, the permit is absolutely explicit that you have soluble metals within the IBA.
Say that again, sorry.
The permit is explicit, my
Yeah.
lord, that there is soluble metals within
Yes.
the IBA.
Yeah, so the authors of the permit explicitly recognise that heavy metals dissolve.
That's correct, my lord.
And we see that from Schedules 3 and 4.
It's, yes, so Schedule 3, my lord, so page CB 176,
Yeah.
references to bottom ash.
Total soluble fraction.
Yeah. Total soluble fraction of metals and metal soluble fraction having listed those various elements.
And
And then that's picked up again in Schedule 4, which is CB 178.
alright, let's just find that. And those are not references that you can derive from the supporting document.
In terms of supporting information,
Yeah.
there's two points to make. One point to make on 2245, and then I'll deal with one further reference with that. In terms of 245, the point my lord made this morning about the sentence was the correct analysis. The sentence simply doesn't make sense. That it is simultaneously saying that material will be in solution and not dissolved.
Yeah.
And
Which is even for a non-chemist a difficult concept.
my lord, it's sort of key. It's key. It's key.
It's a challenging concept.
A reasonably well-educated 13-year-old would spot that sentence doesn't make sense, and that's the point of making the respondent's notice, is that is actually the error in the sentence. Not as the learned judge below thought that the sentence would be read as meaning that it will not be dissolved, and when it refers to in solution meant in a suspended solids, but actually you've got a sentence which on its face, like anything about metal salts in particular, is obviously wrong. Now, the supporting information does actually get the point right elsewhere.
Oh, does it?
There's a reference which we haven't seen. So if my lords could go please in the supplementary bundle to SB 36. And that is paragraph 266, which is discussing potential treatment techniques for IPA. And one of those is kicks off with wet treatment systems. Use water to wash soluble salts with the IPA. And then explains why that's not actually a good technique to use and why people don't use it. But it is a recognition in that document that in the supporting information that salts are soluble. So my lords, taking the point as a whole, taking the document as a whole, whilst there was a sentence which went horribly wrong. We've all written sentences that go horribly wrong. The Cavanta did understand what the position was. To take the point which follows as to how paragraph 245 is used and how it works, I think is my Lord's point this morning particularly, that obviously what is said about what interceptors do is correct, that they deal with solids and they will deal with oils, things that will be separated from the water. What of course they don't deal with is anything that's dissolved. So my Lord's right to have in mind that what is said at the end of 245 about interceptors isn't an answer to a dissolved solution. The answer to the dissolved solution are the measures which I've identified in terms of avoiding the spill, the clean-up, depending on the salt. It is worth having in mind that when Cavanta in the supporting information is dealing with how there is compliance with Article 46.5, it refers, and my Lord, the reference to that is in SB 39.
Yes.
It refers to section 244
Yes.
rather than 245. 244 we've looked at. That's the contaminated water section, which includes the reference to the septic, but also the penstock valve, spillages, and so on.
So the table 2.9. Yes.
Now, turning back to the question of the agency's understanding, the decision document contains one reference which is particularly for assistance. My Lords have seen this before, but it's SB 238. Which is the same at the top of SB 248, which is where there was the quotation from paragraph 245. And the representation summarised by the agency concerned with recirculating water. And also, that is a reference to process water. Resulting in heavy metal emissions, silt traps will not prevent the release of dissolved metal solids in ash water runoff.
Sorry, you're reading from?
238, the representation
Yeah.
at the top, the one that begins the statement.
Yeah,
the
sorry.
application.
I've got that, yeah.
So after quoting
Recirculated water, yes.
recirculating water, the silt traps won't deal with that. Now, the agency response to that is actually it's correct and is actually one which does actually answer the question being put, which is the concern about the recirculating water. And what the agency says, well, there's not going to be a mistake as is going on within the enclosed facility. And it won't be escaping. What the agency don't do is to say, oh well, the metals won't dissolve. The person making the representation correctly understands the position that there may be dissolved metals. And the agency say, well, that's fine in the context we're talking about with the process water, because it's not actually going to escape. So they answer the question, but also in doing so, that's totally consistent with, I'd say, somewhat supportive of the agency understanding that there may be dissolved metals within that. And also that then takes me, if I may, to the legal questions which follow. This claim has been put on the basis of a mistake of fact or mistake of science, but in reality it amounts to the same thing in the present context. Put on the basis that the agency misunderstood contents were being failed to appreciate, the metal salts might dissolve. The practical consequence which the claimant would want the court to draw from that, in terms that it goes very much discretion as materiality. Practical consequence would be saying, well, the agency granted the permit, not having in mind the possibility of dissolved metal salts getting into surface water. So therefore that matter was left out, and there may be some different outcome. But my lord, the way that was then put was on the basis of the agency having made that mistake. The agency did not make that mistake. The learned judge was quite right to say that the agency did not make that mistake. And the law was given the reference to the permit. There can only be one conclusion: the agency did not make that mistake. So the agency were dealing with this permit application on the basis that there may be metal salts in the IBA which were soluble. I've explained, and Mr. Williams has explained, how those issues are addressed in the processes which are put in front of the agency and the consent that's given. For the appellant to succeed, there has to be some public law error in how the agency then dealt with that. Now, on the basis the agency did not make the mistake alleged, there is, by law's no pleading basis. I don't take a pleading point here, but it's worth noting that none of the public law bases were taken. There is no basis for public law error. The agency understood what the position was. In terms of Article 46(5), I've also looked at it plenty of times. It's concerned with pollution. We've looked at the definition in Article 3 of the Directive in terms of what may be harmful to humans or the environment. And it's about that pollution getting into, amongst other things, surface water. It's not a prohibition on dust emissions. It's not a prohibition on fugitive emissions, in the sense of the IBA get out, but it's a prohibition. It's to design and operate in a way that prevents the pollution reaching those vulnerable receptors. So simply say, oh well, or to somebody say that they're bound to be dust emissions or what have you, isn't going to be a breach of 46.5. So it's about avoiding those elements of harm. And in the context of the permit decision, the decision is whether or not to proceed, whether or not to allow it to proceed. And that does involve the agency addressing, as it does, by Lord Seaton references, Mr. Williams taking the court to, and Cavanta have done so, and I take the court to those, involve considering Article 46(5), whether you would prevent. And that's looking in the context of not necessarily excluding any possibility of a problem ever occurring, but is the design, the operating measures capable of what you can expect to actually comply with that? But of course, if there's subsequently a breach, then that would be the ordinary course of things in an offence, and further steps to be taken to make sure it doesn't happen again as well. But here we're concerned with granting a permit. So to take a more commonplace planning example, you may well decide that a particular pub, for example, or an industrial unit is capable of generating noise which could be harmful to neighbouring residential occupiers, and there may well then be a noise condition imposed. Now, it doesn't exclude the possibility that at some point there may be a breach of that noise condition, but proceedings can be taken in respect of that. It's all ground consent. And clearly, if the decision maker took the view, well, it's pretty unlikely that this condition would be complied with, and that's a reasonable refusal. But don't refuse, going back to environmental permit, 46.5 does not require a refusal on the basis that it is possible something might go wrong.
No.
If the measures are, if you've designed it, you've set out how you intend to operate it, in a way which should prevent that, then that in those circumstances is permissible. We've set out measures to do that. So 46.5 doesn't set an impossible bar, but it's one which the agency were conscious of and applied. So, my lords, that takes me back to the question which I posed in these final submissions. What public law error might there be? Having correctly understood what they had to do, correctly understood the material, the only point that can conceivably be left is an irrationality, an argument that no rational decision maker in the position of the agency could have reached a conclusion that this was an acceptable means of operating an incinerator.
Well, it hasn't been put on that basis.
Indeed, it hasn't, my lord, and that is a step which is far too high to be reached, even before taking the point from learned friends taking the court to from Mott and Levy, that this is a specialist regulator with the scientific expertise to be making judgments, and one which the court should find itself even more cautious before second guessing.
All right.
If the effect of the substance of my learned friend's submissions to the appellant is to invite the court to conclude that the measures which the agency thought were acceptable are not acceptable. Whether that's dressed up as rationality, however it's dressed up, that's an impossible task. I was conscious I've knocked my time estimate a little bit, but I hope what I've said has been of use. Unless there's anything else I can help the court with.
Thank you very much indeed, Mr. Hall. Thank you. Is there any reply, Mr. Stephen Jones?
Yes, my lords. Just
Can you, without rushing, manage to do that by 25 to 5?
certainly.
Thank you. That's not to say that you must go on until 25.
Subject to your
But I
lordship's
don't.
questions, of course.
I think that does give you virtually what you'd asked for in your provisional timetable.
Indeed, and that was only if necessary. So I will just wrap up a few short points, I hope, arising from what has been said.
Right.
Just beginning, if I may, with 2 points that your lordships were taken to by my learned friends. The first was a reference at page 120 of the supplementary bundle, and there was a reference there, I think this was by my learned friend for the Environment Agency.
Yeah.
It's in the decision document.
Yes.
And the reference there was the discussion of other emissions, and that paragraph, final paragraph before we get to section 6, we agree that the applicant's assessment, that the risk is low. And then on it says, in addition, proposes control measures, etc. And the details can be found in the section we've read a few times now, 653. The point there is that that approach is wrong, given, as a matter of law, given what's contained in Article 46.5. It's not that there should be, that the Environment Agency should be satisfied that there is a low risk, but rather that the plant is designed first of all and then operated such as to prevent any unauthorised or accidental emissions. So this, in a sense, encapsulates or is characteristic of the approach that's been taken here, which we say is erroneous in law. That what's being said effectively is that there's a very, very low risk, and that is in fact what Mr. Harwood was just saying at the end there. That the plant, that you can never, as it were, legislate for all potential accidents and emergencies not to occur, and that wouldn't be a basis for refusal. We, first of all, we're not suggesting necessarily that this should be refused, but rather that the Environment Agency should pick up on the point and go and seek to ask further questions or address it in some way with Covanta as the developer, precisely in the way that some of your Lordship's questions were directed, i.e. how are heavy metals, dissolved heavy metals, to be prevented from entering the wider water system through the attenuation pond. So it's never been a part of our case that the permit should necessarily be refused purely on that basis. Of course, if there's an alternative that can be arrived at that does deal with heavy metals, dissolved heavy metals, then of course that could be reflected in a revised permit or a particular provision within a new draft. The second reference, my lords, that you were taken to was by Mr. Harwood, and that was at 275 of the supplementary bundle. And this was in the context of a discussion you'll remember about tarpaulins. And the point here, and your Lordships will remember, and I don't want to repeat myself, but it is important just to highlight here that again your Lordships were taken to this tarpaulins point, is exactly here again you get it will be sufficient to minimise emissions. So we're in the realm of minimising and again not preventing. And I gave you the other references in 275, 276 and 277 to similar indications, as it were, of approach. So both of those examples which your Lordships were taken to are actually indicative of the approach that we say is problematic in this case. The point was made by my learned friend, again, for Covanta. He's emphasised the, or sought to, as it were, delimit the potential for dust emissions to spillages, effectively, and to accidents on the road and so on. Now, of course, that is one major potential concern and source. But again, my lords, I would point your Lordships back to the dust management plan at page 304, 4.2. We get the list there of the potential sources of fugitive dust and particulate emissions. And again, I don't want to repeat myself, but it's very important to remember that this isn't just about spillages. It's about the everyday operations of the site and the fact that very small amounts may be emitted. Fugitive emissions are not purely an emergency situation. They may well just be dust that's carried on vehicles, on wheels, on clothes, and so on. It may well be that the risk is small, but as we know, the pollution is cumulative potentially. And once again, the dissolved heavy metals will not be intercepted by the proposed technique. A related issue in relation to that is the penstock valve. Now, that, of course, it's an important protection, but it's a protection that can only be employed once it is known that there is a spillage or there is an emission, and that can be isolated and therefore shut off by virtue of the penstock valves. It doesn't answer the larger question, if I can put it that way, of the cumulative, albeit very, very small potentially, emissions that may occur in the everyday operation of the site. It's a small point, but just one that I'll just mention, which is that the pleading point that neither of my learned friends say they want to take, but do mention. I just refer your lordships back to paragraph 3 of Mrs. Justice Lang's judgment, where she does describe what the ground was, and it was that the fugitive emissions management system was premised upon an error of fact. So the two things are related and have been right since the beginning of the claim. And it isn't purely that the Environment Agency had to consciously adopt an error of science in some sense, but rather that the product of the error was the employment of an ineffective operating technique.
The judge does deal with the issue between the professor and the agency, as it were. Is there anything you want to say about what Mr. Harwood described as either the presence or absence of practical alternatives?
Well, I revert, as it were, to what I said this morning, which is to say that, of course, it would be a judgment ultimately for the Environment Agency to make once they had, as it were, addressed this issue in the permit. Then, of course, it would be a matter of whether they say that this has to be, we have to remedy this by precipitation, or we have to remedy it by, you transporting the water off-site to a licensed facility, or some other method. But the point, that's a later stage, and that would be a matter of expert judgment, and we would entirely agree with that.
Yes, but if there's no practical alternative, then it's hard to escape a conclusion that the decision couldn't be different.
Well, my lord, Mr. Harwood didn't say there wasn't a practical alternative. He said that the alternatives effectively Covanta hadn't.
Yeah, no,
I
I wasn't summarising his position as being that. I just wanted to hear what you said.
No. Well, indeed. I mean, if there was no other option, well, then there's a choice between is this facility safe in accordance with the directive, and can it therefore be permitted at all, or is there some other mechanism, some other way of addressing this issue within a revised permit? And both those judgments are not judgments I asked this court to make, of course. On that, in a sense, the key piece of evidence, if you like, it's our ground 3, of course, is the dust management plan. I would emphasise that it's not a dust eradication plan. It doesn't express itself in that terms. It expresses itself in terms of managing a problem of dust. I mean, that is what is going on in that document, and I've taken your lordships to the references to minimising and all of those things, which I don't want to repeat, but it's important, therefore, we say that stands as a piece of evidence that there's a problem here. I didn't address your lordships earlier, and I probably just should address for completeness, but we do say that there's no place here for the application of the Senior Courts Act, section 31A 2A. It's impossible to say at the moment, and there isn't enough evidence, as your lordship pointed out, to be able to say that the decision would be exactly the same. We would need the Environment Agency to look at this matter afresh and see what they.
Well, the section 31.2a is not simplex. It's highly likely. It's the highly likely test, or highly unlikely to have been different, or substantially different.
No, it's not simplex. No, it's not. But I mean, we say that it would not. It isn't highly likely.
Yeah, you say that. Yeah. However, section 31.2a is formulated. This is not such a case.
No. Those are my points. Can I just check, because I haven't taken any instructions. just there is one point which I think is worth just looking at in the permit itself.
Yes.
Just returning briefly. So if we look at condition 3.2.1 again for a second. Again, this is perhaps indicative of the approach being taken that may be more akin to an Article 1 approach, if I can put it that way, rather than a Article 46.5 approach. If one reads that paragraph again, 3.2.1, especially to the final sentence there, have been taken to prevent or where that is not practicable to minimise those emissions, then that condition, rather than being evidence of compliance with 46.5, in fact, appears to mirror the approach envisaged under Article 1. So it cannot therefore be a complete answer. We would submit to the requirement to comply with Article 46.5. I think those are our submissions, so
Thank you. Just one question which you may be able to help us with. If you come to CB 164, which is within the permit, Schedule 1,
yes,
it's this point about the incorporation of the supporting information document and the submission made on the other side that 2.3, where it stands alone like that, must mean, if you look at the approach adopted, it must mean the whole of 2.3. Is that accepted or not?
my lord, that was a point that hasn't been made by my opponent up to now. I mean, I don't think it actually affects our case, because the point is that 2.3.1, I think it is, which contains the requirement for periodic testing,
Yeah.
doesn't
You say
indicate
periodic testing is after the event anyway, so it doesn't matter.
exactly.
Right. So you're relatively relaxed about that in any event. Is that a fair way of putting it?
I think that is a fair way of putting it. Thank you.
Very much. Well, thank you very much, Mr. Stephen Jones. We're grateful to all of you for your very clear and helpful written and oral submissions. We're grateful to all of you too for having admirably stuck to the provisional timetable which you kindly gave us yesterday. Thank you very much for that. It is very much appreciated. We're going to reserve our judgments to reflect on the submissions made to us. In due course, therefore, a draft judgment will appear for typographical corrections only. No re-arguing of the case, please, at that stage. The parties should make every endeavour to agree the order, and in that event, which is what we would expect, there will be no requirement for attendance